Efforts to prevent former President Donald Trump from running in the 2024 election are gaining momentum. This move is based on a section of the 14th Amendment to the U.S. Constitution, which states that an elected official cannot hold public office if they were involved in insurrection or rebellion against the United States, unless they receive amnesty through a two-thirds vote in Congress. Advocacy groups argue that Trump's actions on January 6, 2021, when the Capitol was stormed, qualify as insurrection. However, Trump has denied any involvement. The effort to disqualify Trump under this constitutional clause gained more traction when two members of the conservative Federalist Society, William Baude and Michael Stokes Paulsen, supported the idea in a legal article. Retired federal appeals Judge J. Michael Luttig and Harvard law professor Emeritus Laurence also made the same argument in The Atlantic. Legal challenges against Trump under this clause are emerging in various states, including New Hampshire, Arizona, and Michigan, where a lawsuit was recently filed. Secretaries of state are preparing for the possibility of elections without Trump as a candidate. Michigan Secretary of State Jocelyn Benson and her counterparts from other states began discussing this issue over a year ago. They anticipate multiple decision points throughout the election cycle. Despite the growing conversation, some legal scholars and election officials are concerned about the practicality of these lawsuits. They question who has the standing to bring these challenges and how they will be handled procedurally. In New Hampshire, lawyer Bryant Corky Messner, endorsed by Trump during his 2020 Senate run, is taking steps to challenge Trump's eligibility for the primary ballot. New Hampshire's Secretary of State confirmed this but clarified that they haven't taken any action against Trump. In Michigan, citizen activist Robert Davis filed a lawsuit urging Secretary of State Benson to declare Trump ineligible to run for office. Davis requested a decision within 14 days. Benson stressed her commitment to upholding the law and acknowledged Michigan's pivotal role in the election. Arizona Secretary of State Adrian Fontes is planning for challenges to Trump's eligibility, but lacks the authority to bar him from the ballot. The Arizona Supreme Court ruled that only Congress could enforce the disqualification clause, a decision Fontes criticized. Fontes anticipates lawsuits regardless of the outcome and is preparing in advance to minimize disruption to the election process and election workers. Legal experts, including Harvard law professor Emeritus Laurence, expect the issue to reach the U.S. Supreme Court. Trump's eligibility could vary from state to state until a uniform rule is established through court decisions. In Ohio, Secretary of State Frank LaRosa's office is unaware of any litigation related to this issue and does not anticipate denying ballot access to candidates who comply with Ohio law. Efforts to prevent Trump from running in 2024 are becoming a national conversation, and the legal battle is expected to escalate, potentially reaching the Supreme Court. The outcome will shape the future of Trump's political career and influence election procedures in various states.